What is a remand of an ERISA disability insurance case? It's not uncommon for an ERISA disability insurance claim to end up either in federal district court or even at the federal circuit court level. I'm often asked, what are the possible outcomes that could come out of this litigation? Well, courts can do a number of things. The first thing they can do is uphold the claim denial and say that the disability insurance company was right. The second thing they can do is to reverse the denial and award you the benefits. The third thing they can do is to uphold part of a claim denial and reverse part of the denial and award benefits. And one of the last things they can do, and one of the ones that drives us nuts sometimes, is reverse some or all of the denial and then remand the case back to the plan administrator or the disability insurance company to reconsider the denial. In my view, this does nothing more than give the disability insurance carrier or the beneficiary a second bite at the apple to get that denial right this time. So it's very difficult for you to overcome it either on appeal or when you're in federal court. Now, you have to understand that this administrative claim process has to be exhausted before you get to file a new lawsuit. So what happens is the case goes back, they make a decision, and you have 180 days to appeal. They've got 90 days in which to make a decision, and you're getting emotionally and financially exhausted. I'm often asked, well, why is a case remanded? They're going to remand it or send back a denied claim if, for example, the disability carrier applied the wrong standard in determining a claim. They may have applied a wrong policy or plan term in denying the claim. Or the disability carrier or the plan administrator may have misinterpreted a policy or a plan term that's not consistent with the definitions in the policy of the plan. They may have failed to follow basic ERISA claims processes or procedures. They may have failed to consider relevant information like a Social Security decision and award of benefits. They may also have failed to provide a full and fair review by explaining in the denial letter what you, the policyholder or the plan participant, has to do to file an appeal to address the basis of the denial. Now, that's a lot of reasons why a case could be remanded, but I wonder whether a federal court even has the power to order a remand. And in reality, I think it's a puzzling question because there's nothing in the ERISA statute that provides for a remand. Yet, federal courts remand ERISA cases all the time, and in doing so, they do follow established appellate rules for remands, as can happen in non-ERISA cases. I'm really hoping that one of these days, the United States Supreme Court will rule on whether federal courts even have the power to remand an ERISA case back to the plan administrator or the disability insurance company. And really what we want them to do is to make a decision on the case. We want you to have a decision that either awards your benefits, reverses in part and awards benefits, or simply upholds the denial. We want a definitive answer, don't you? I'm Nancy Cavey. I specialize in disability law, and I've taken disability insurance companies on across the United States. If you have any questions about your ERISA disability policy or plan, call me today at 727-894-3188 for a complimentary consultation. I look forward to helping you get the disability benefits you deserve regardless of where you live in the United States.